Oh, Your Honor.
Hello, are you Roberta Monreal? No, but she isn't.
No.
No, you need to.
I got excited. I saw you.
Oh, no, hi. Oh, yeah, all right, so let me explain something to you. I understand that you're his parents, and he seems very young to me. But once they're charged with a felony offense, they're considered legally to be an adult, right? So you're not allowed to come up here with him unless you're coming as witnesses, okay? But you can come to court and everything, but he's here with his attorneys, all right? And what I can tell you is this, because I know parents are concerned. We want to be involved, right? And we want to know everything that's happening. But this is what I'm going to tell you. I've been a defense attorney before, and I'm sure they'll tell you, if you are in on their meetings with him where they're discussing things, it's no longer confidential. That means that the state can call you as a witness to figure out, if they want to, what happened, what was said. So even though you're his parents, he's an adult, they're his attorneys. What I can tell you about these two attorneys, nothing's going to happen unless y'all know about it. Nobody's going to, yes.
Those are the victim's parents.
That's the victim's parents.
Oh.
His mom is in the courtroom.
Ah, hey, Mom.
There's the victim's parents.
Okay, they said they were the parents. All right.
No, I'm not his parent.
Okay, so you all need to step back. Whoa. Hi, Mom. Everything's going to be fine. All right. All right. So you want an appointment of a second chair,
Yes, Your Honor.
and that will be granted. And I'm assuming, are you retained or no?
Well, as part of the bond situation, yes. As part of the bond conditions, I am retained.
All right. So what I'm going to need to do, if you want the court to appoint a second chair, I need to get some information about his finances.
I can tell you, it was a big effort to make the bond, and I can tell you that he is.
I need to call him to see. All right. Court is calling 2025 CR 006058B, State versus Roberto Monreal. Can I have parties announce?
Nick Aguilar on behalf of Roberto Monreal.
And I'm sorry, this is just for an appointment of a second chair, State.
Understood.
All right. And are you Mr. Monreal?
Yes, Your Honor.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand, state your name for the record.
Roberto Monreal.
All right. So, defense, you're asking for the appointment of a second chair?
Yes, Your Honor.
All right. If you want to ask your client questions about financial.
Absolutely, Judge. You already stated your name.
Yes, sir.
And how old are you?
I'm 18 years old.
And how long have you been 18?
A month, short of a month.
Okay. And are you currently working?
No, sir.
Okay. And before you bonded out, how long were you in jail?
About 3 months.
Okay. And before those 3 months, were you working?
No, sir.
So you have no assets at all in your name?
No, sir.
Okay. And where are you living?
With my mom.
And your dad lives in
Phoenix.
Phoenix, Arizona?
Yes, sir.
Okay. I know it was a group effort to make the bond, right?
Yes, sir.
Between your mom and dad,
Yes, sir.
and they're separated, divorced.
Yes, sir.
Okay. Do you have the funds to hire a second attorney on the capital murder?
No, sir.
Have you looked into it, or your parents looked into it?
Hiring a second attorney? Yes, sir.
Okay. Roberto, are you currently going to school?
No, sir.
Have you graduated from high school?
No, sir.
How short are you from graduating?
3 credits away, sir.
You're currently on GPS monitor,
Yes, sir.
and how are you paying the monitor fee?
My mom is, sir.
So you can't even afford a $300 monitor fee
No,
yourself?
sir.
All right. I'm going to grant the motion. I'll appoint a second chair. And then state who's going to be handling this case. All right. Mr. Garehan, on this case, are you all proceeding on this as a capital murder?
I'm sorry, Judge, I don't know which one this was.
Roberto Monreal.
As in capital, I believe it was murder and that robbery.
Well, in count one, you do have it as a murder, a felony murder.
Correct, Judge.
All right. And then count two is an aggravated robbery.
Is Judge. And for the record, I was the court-appointed second chair to Suzanne Kramer before Mr. Aguilera filed his notice. So that's why I'm.
Okay. All right. So I've granted the motion to have the second chair. And for the record, as she stated, he was previously appointed Miss Suzanne Kramer as first chair and Miss Guerrero as second chair. And that the attorney, Mr. Aguilera, was retained to make the bond. Right. So we can go off the record. So on this case, where are we? Let me see where the other cases are set.
This one was supposed to be set for a bond reduction today. That's why we were out of order.
Okay. All right, Norma, when are the other cases set?
All of them were set for today, Judge.
Okay.
Only two are set for today. One was pushed for next week because the council was out of town.
All right, so then what we'll do is let's get a discovery date on this one. And we'll do, because of the nature of the offense, put me at 45 days for discovery. All right, so we're going to recall it July 24th for, all right, and my understanding the complainant's family is here.
Yes, Judge.
And so, if you could move this way, to all the parents in the courtroom who are involved in some shape, form, or fashion with regards to these cases, I know that emotions run high. I thank you for not causing any problems coming up, so I appreciate that. So I just want everybody to know that all the people involved are deemed to be adults legally by the court. So I understand that emotions can run high, but I want to remind everyone, we can't do that inside the courtroom and hopefully not outside the courtroom. Just let the legal process, sort itself out. And so to all the persons who come down, who want to see something that is happening in regards to these cases, the first part of the legal process is for me to make sure that the defense has all their discovery so that if someone decides they want to go to trial, they can go to trial. It does no good for people not to have all their discovery and put them to trial, because then that's not fair. So everybody needs to have a level playing field that's fair. So that's what's happening today. So on all of these cases, if there are parents here today related to these cases, it's not going to trial today. It's being reset for discovery. And this case is being reset for discovery for July 24th. All right. Thank you, everyone.
Thank you, Judge. I would be excused.
Yes.
And Judge, just so you know, I'm supposed to be on a murder trial on 186 that date, but I think Mr. Aguilera can handle it.
Yes. We're just doing discovery, but thank you.
Thank you, Judge.
You're welcome.
May we be excused?
Yes.
Thank you.
That excused.
Yes.
I was at church 2 weekends ago.
Good morning, Your Honor.
Morning. How are you doing?
I'll get by. You ready, Ruby?
I am ready.
You understand?
Yes, sir.
Okay.
Hello. How are you doing?
I'm fine. How are you?
Oh, I'm doing okay. All right. So you all ready to proceed on the motion to revoke?
That's right.
All right. Court is calling 2020 CR 7910 State versus Ruby Caceres. Could I have parties announced for the record? State
Virginia for the state of Texas.
James Seeloff for the defense.
and counsel. You need to have her sign this. And are you Ms. Caceres?
Yes.
Are you the same Ruby Caceres who was placed on deferred adjudication in 2020 CR 7910 for the offense of assault family second offense on November 13, 2020 for a period of 3 years? Is that you?
Yes.
State?
Yes, Your Honor, we're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation of condition number 41. On or about the 20th day of May.
I need a motion to revoke stamp, please.
Yes.
All right, you may proceed. Sorry.
On or about the 20th day of May, 2025, in Bear County, Texas, the defendant, Micaceres, did then and there failed to comply with the rules and regulations of the felony drug court, and that the defendant refused to participate with program requirements in violation of condition number 41.
How do you plead to that? True or not true?
Excuse me.
True.
How do you plead to that? True or not true? All right. Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes.
Court will find violation of condition number 41 true. Is there a proposed agreement?
Yes.
There is, Your Honor, that is to revoke the defendant and adjudicate guilt and sentence the defendant to 5 years to DC.
All right, counsel, is that the agreement?
That's our agreement. And I'm going to ask, we're going to ask for credit for time served, which means she should be out pretty quick.
Right.
She's been in that long.
Are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
Yes.
Thank you.
All right.
That was a paper we signed.
All right, the court is going to follow your agreement, find you guilty, revoke, sentence you to 5 years in the prison, credit for any time served. There's an affirmative finding of family violence. There should be no harmful or injurious contact with Ricardo Caceres, and the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right. Good luck to you.
Your Honor,
Yes.
just to make clear, the court, I'm asking the court to take credit for time served
No, she'll get credit for any time that she's been in custody. Now,
on this.
here's the thing. You've been sentenced to 5 years in the prison. My ruling gives you credit, but that credit goes towards the 5 years in prison. Whether you're getting some extra time from the Bexar County Jail, 2 for 1, 3 for 1, that's completely up to the Bexar County Jail. Whatever the prison system wants to give you credit for, that's completely up to them. The only thing that I can give you credit for is the time that you've been in custody while this court has had jurisdiction. Do you understand?
I understand.
All right. Good luck to you.
Thank you, Your Honor.
Oh, wait 1 second. Yes.
The victim is in the court mirror. He wanted your permission to address the defendant. I don't know if this is accurate.
It's not. Who is the complainant?
Brother? Is that your brother?
All right, Mr. Caceres. Here's the thing. I understand that your sister has some mental health issues. Yeah. You know, I did all I could. There's nothing else I can do for her. I sent her to felony drug court. She doesn't want to go to felony drug court. So when she's released, I'm sorry?
I appreciate that you did not release her because she's going back.
All right. All right, what's the name?
Isael Dominguez Serna.
Oh, okay. I have that.
Thank you.
All right. Maciel Dominguez Serna. All right. Is your client a citizen or no?
He is not.
Did you speak with an immigration attorney or you are going to do that on your own?
Oh, no. Well, I was spoken to him in Spanish, Your Honor. He's been referred to we consulted with him with other immigration attorneys. So he's aware of any immigration consequences to any kind of plea.
All right. And sir, how old are you?
23.
All right. This was previously set for a plea deadline date, but I know you were in jury trial. So this is being reset for the week of June 23rd for a plea deadline date. At that time, you all need to make a decision on whether or not you want a jury trial, bench trial, if anything is not worked out.
Yes, Your Honor. He has been sent to PTD, and a client will be pursuing PTD. So he should be enrolled on or before, or should be on the program by June 23rd, Your Honor.
All right, Ms. Ferguson, give me a PTD date, please. All right, July 17th. Thank you.
Thank you, Your Honor.
Once you sign the reset form, you're excused. Thank you so much. Good morning. How are you doing?
Great, thank you. Thank you very much.
You're welcome. All right, Miss, where is she?
Hi, Your Honor.
Hi, so you were recently in jury trial? Were you?
Yeah, I had one up in 399 and he pled guilty. So I asked the service to try to reset it for me and they were able to. Subsequently, but I was trying, did I give the court the proper notice?
You did. I was just wondering how things went.
Oh, he pled.
Okay. All right. So on Adriana Ramos, before we get to bond conditions, where are we on discovery?
I've gotten some, but I don't think I got it all because it looked slow.
Yes, we're actually missing the file down here. Your Honor, I need a request from upstairs so I can confirm that what exactly he's missing so I can try and get it to him. Additionally, I think he's got the bond stuff that we need to call the victim on as well too.
All right. So y'all are not ready to approach. They need to call the complainant with regards to the bond.
And if I could clean up my motions incorrect. The no contact order is with respect to the man she allegedly cut. The two kids are with him. I told her, don't do anything to go get those kids because she can't have contact with him. I guess what I think is for the best is a court to order how that will be done because she can't have contact with the father.
Okay.
Does that make sense?
Oh, yeah. It makes sense to the court, but you need to confer with the state.
Okay.
All right. Thank
Very
you.
well.
Thank you. All right. So where are we with discovery?
I'm still lacking a little nugget with them. It was pretty short, and I think other decisions are still outstanding.
Yeah.
All right. Yes. I'm sorry. No. Go ahead.
I should be ready by the next setting to provide him with an offer.
All right.
For discovery.
All right, Ms. Ferguson, I need discovery and an offer is going to be due in 30 days. All right. And then with regards to the visitation, she'll need to do it through a third party. She still cannot have contact with the
Okay.
complainant. Do you understand? All
Would it
right.
be, she's living with her aunt? And is that okay, Your Honor? She's living with her aunt. Her mother died last week.
All right. So whoever they approve of for a third party, they'll have to approve. You know, that's something that they need to work out because I'm sure based upon this offense, is there a civil suit or no?
I don't believe so, and I don't believe CPS is involved yet of what we know.
All right. So here's the court's quandary. I will allow her to have visitation, but it has to be supervised. And the reason why I'm doing that, I don't know anything about this case. I don't know why Child Protective Services isn't involved. Usually they would be. So I will allow you to have supervised visitation with the children. All right. Is there anything else?
Just how, I want to just make sure I'm clear. Who contacts who to set this up?
She'll need a third party to do that.
Okay, and recommend that to give that name to the probation officer.
No, because she's not on probation. Am I correct?
I'm sorry. Yeah,
Yes.
I'm just making sure who she can't talk to the husband. Who should she talk to get that set up? I'm going to use mamas and aunts if that's okay.
Yeah, because this is becoming a civil matter and I'm not the civil attorney.
Yes.
So I'm saying that she can have supervised visitation with minors. I'm not saying her minor children because this is not a civil court. And if something happens during visitation, that's not going to be because the 187 district court judge has ordered something that I should not order. So what I'm saying, if she has contact with any minors, it must be supervised.
Okay. And so we'll agree on supervision with the DA's office and let them know who's doing it.
Okay.
I understand the court lacks jurisdiction to say too much.
Yes.
I understand.
All right. Once you sign the reset form, you're excused. Thank you. Hello. All right. His plea deadline date is not till June 23rd. I said his plea deadline date is not until June 23rd.
Thank you, Your Honor.
All right. That's what I have on the docket sheet. So you are here requesting a bond reduction?
Yes, Your Honor. He has three cases.
Mhm.
The aggravated robbery allegation is $50,000 currently. And on the unauthorized use of the vehicle and the controlled substance case, they're both remand without bond. Respectfully requesting you set bonds on those two cases.
So it's the unauthorized use of a vehicle in the possession case. There's no bond?
That's correct, Your Honor. Do you need the cost numbers?
Oh, no, I have your motions.
Thank you, Your Honor.
All right. Have you all been able to confer on a bond amount or no?
We have, Judge.
Is there agreed bond amount or no?
I don't know if that's an agreement. That's the statement recommendation.
All right. So unauthorized use, I'm sorry, you're requesting how much?
1,000,
And on the possession less than a gram?
3,000.
So are you in agreement with that, counsel?
We are, Judge.
All right. We're going to go on the record. Court is calling 2025 CR 001601 and 2024 CR 009596 State versus Clinton, Dwayne Dixon. Can I have parties announce?
Robert Featherston representing Mr. Dixon.
And are you Mr. Dixon?
Yes, ma'am.
Okay. All right. We are here on two cases where counsel, you're requesting bond. And then on the 2024 CR 012476, are you requesting a bond reduction on that or no?
We are, Your Honor, and that's not agreed to.
All right. So let's start with what's not agreed to.
All right, Your Honor.
All right. In 2024 CR 012476, counsel, would you like to present evidence for your motion?
Your Honor, I would proffer to the court that Mr. Dixon is indigent. He is also homeless, has no funds whatsoever to post a bond, and currently a $50,000 bond in his circumstances is an instrument of oppression, as outlined in our Texas Constitution under current law, which may change in September. But under current law, it's an instrument of oppression. and we respectfully request a reduction of his bond in light of that fact.
And what is the current bond? $50,000?
$50,000, Your Honor.
All right, state.
Whether Mr. Dixon is indigent or not remains to be established since he has not actually provided any evidence. I take Mr. Featherston's statements as true on their face, but they do not in and of themselves constitute evidence. For the court to make a decision on this issue, the court should have some evidence on which to make its choice.
All right, he's saying he was making a proffer. Do you object to his proffer?
No.
All right. So there's no objection to your proffer. So you're saying your client is indigent?
That's correct, Your Honor. Also, I'm court appointed to Mr. Dixon because of his indigent status as established by the court.
All right. Then with regards to a bond amount, is there any evidence, any other evidence you wish the court to consider, state? All right, Mr. Dixon, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Lenny Dixon.
All right, and if you were released on bond, do you have a place to stay? Where would you be staying? Where would you be living?
I'd go like to my grandma's house or something.
Well, here's the thing. You say go back to your grandmother's house or something. Have you asked your grandmother if you can stay with her?
I have a key to a house.
No, that's not my question.
Yes, ma'am.
I have the keys to plenty of relatives' house. That doesn't mean that I could stay there. I'm sure they'd have no problem, but no, my question is, did you ask her whether or not you could stay with her?
I could stay there anytime.
No, my question is, did you ask her? That's either yes or no.
No, ma'am.
All right. So if for some reason you're not allowed to live with your grandmother, do you have any other place to live? All right. Now, at your grandmother's house, who all lives there other than your grandmother?
Just my grandmother.
And have you ever in the past been diagnosed with any mental health issues?
Yes, ma'am.
And what would that be?
Schizophrenic, bipolar, ADHD.
All right. And in the past, have you ever used any type of controlled substances, any type of drugs?
Yes, ma'am.
And what would that be?
Marijuana, ecstasy, crystal meth.
All right. Any other question?
No, Your Honor. The mental health issue is very active.
All right. And the court will note for the record and take judicial notice of the fact that Mr. Featherston is court appointed. And in order to receive court appointments or for a defendant to be appointed counsel, they have to meet financial requirements. And how long have you been in custody, Mr. Dixon? 9 months. Do you have any bank accounts with any type of savings?
No, ma'am.
All right. Do you have any funds whatsoever?
No, ma'am.
Do you have any money on your commissary account?
Not at the moment.
All right. So defense, what are you asking for bond?
Your Honor, we respectfully request a bond of about $10,000.
All right. So I can tell you the $10,000 is not going to happen, but state, what are you requesting?
1,000.
All right. The court will grant your bond reduction. The court will set it at $35,000. There's going to be a GPS partial for medical appointments, waive DPS fees. There's going to be a referral to Center for Healthcare Services, regular UAs, waive fees, and intensive outpatient treatment for substance abuse, waive fees. All right, Ms. Ferguson, if you can make sure he has his reset form for his upcoming
23.
discovery.
Yes.
All right. Is there anything else?
No, Your Honor.
All right. Thank you.
Thank you, Your Honor.
You're welcome.